Elish had been living in fear for 11 days when she walked into a gun store on the north side of Chicago with cash in her hand and a restraining order in her purse. The man who'd been showing up outside her building had a record. The police had been called twice. She had paperwork that said he wasn't supposed to come within 500 FT of her. And she wanted a handgun legal registered hers. The background check took 12 minutes. She passed. Clean record, no flags, nothing. The dealer told her she'd have to wait. Illinois law mandatory 72 hours? And that was on top of the Floyd card she'd had to apply for weeks earlier just to walk through the door. 3 days she went home. The man she was afraid of was not waiting for anything. He did not have a permit process. He did not have a cooling off period. He had her address and no reason to think she could defend herself. That gap between the right the Constitution gives her and the permission structure the state built around it is exactly what the Supreme Court of the United States addressed on May 7th. If you are not already subscribed to this channel, do it right now, because what I'm about to break down is the most significant Second Amendment ruling in American history. And most people watching the news tonight have no idea it happened. United States versus Henderson. That's the case. Consolidated, meaning the court bundled multiple challenges from multiple states and decided them all in a single ruling. The decision dropped on May 7th. Chief Justice Roberts authored the majority opinion. Every justice signed onto it. Thomas, Alito, Barrett, Kavanaugh, Gorsuch. And this is the part that should stop you cold, Sonia Sotomayor, Elena Kagan, Ketanji Brown Jackson. The 3 justices who voted to uphold gun restrictions every single time they had the opportunity. The 3 justices who dissented in Bruin. They signed this opinion. That does not happen by accident. That happens when a legal position has grown so indefensible that even the people who built their careers defending it can no longer put their names to it. The ruling established that strict scrutiny, the highest level of constitutional review that exists in American law, applies to all Second Amendment restrictions going forward. This is not a minor procedural adjustment. Strict scrutiny is the same standard courts apply when the government attempts to restrict free speech or religious practice. It means the government has to prove its restriction serves a compelling interest, that it is narrowly tailored to achieve that interest, and that no less restrictive alternative could accomplish the same goal. Most gun laws on the books today weren't drafted to survive that test. They were drafted under a far weaker standard where courts largely deferred to whatever legislators claimed they were trying to accomplish. That era is over. Roberts made that explicit. The language in the opinion is not subtle. The default is liberty. Restrictions require the highest level of justification. Government may not condition the exercise of this right on permission, approval, or delay beyond what is necessary to verify eligibility. Read that sentence again. Read it slowly, because that one sentence just invalidated systems that tens of millions of Americans have been living under for decades. 5 categories of gun law got struck down, not weakened, not remanded for further consideration. Struck down as facially unconstitutional. Permit to purchase requirements. The systems in Illinois, Massachusetts, Connecticut, New Jersey, Maryland, Hawaii, and Rhode Island that demanded a government-issued card or permission slip before you could buy a handgun. Gone. The court labeled them prior restraints on constitutional rights. That's the same language courts use when the government tries to require a license before you can publish a newspaper. Think about what it means that we tolerated that standard being applied to a firearm purchase for this long and called it reasonable regulation. Waiting periods beyond background check processing time. California's 10-day hold, Florida's 3 days, Rhode Island's 7 days. The court drew a clean line. The government can run a background check. And while that check is running, yes, there is an inherent delay. But the second that check clears, the clock stops. You've been verified. The firearm is yours. Anything past that, any mandatory cooling off period, any administrative hold with no eligibility function, is unconstitutional delay on a constitutional right. Tell that to Maria. Tell that to every woman in a rural county who lives 45 minutes from the nearest gun store and has to make that drive twice because the state decided she needed time to think about whether she really wanted to protect herself. Mandatory training requirements as prerequisites. States cannot demand that you complete a government-approved course before exercising your Second Amendment rights. The court was careful here. Training can be offered, encouraged, even subsidized. What it cannot be is a gatekeeping mechanism. The moment you turn completing an 8-hour class into a condition of owning or carrying, you have converted a right into a licensed activity. Rights don't work that way. You don't have to pass a civics test to vote. You don't have to take a journalism course to start a blog. The Second Amendment is no different. Good cause and proper purpose requirements. The last handful of May-issue states, California, Hawaii, Maryland, certain jurisdictions, and a few others, required you to prove to a government official that you had a specific documented need for self-defense before they would grant you a carry permit. Prove your life is in danger. Get a letter from law enforcement. Show evidence of threats. The court said no. The right to bear arms is not conditioned on demonstrating victimhood. You should not have to be half dead before the government decides you're permitted to defend yourself. And discretionary denial systems. Any permit structure that hands officials subjective authority to approve or reject based on their personal judgment about your suitability. All of it void. Shall issue means shall issue. If you meet the objective criteria, age, no disqualifying background, not prohibited by federal law, they hand you the permit. That's it. No character assessments, no interviews, no calls to your neighbors, no official deciding you just don't seem like the kind of person who should be armed. Those 5 categories form the structural spine of gun control in the most restrictive states in the country, and they are gone. The effect of this ruling is not uniform across every zip code, and that's important to understand clearly. If you live in Texas, Arizona, Tennessee, Wyoming, or any of the roughly 25 constitutional carry states, your day-to-day legal reality probably shifted very little. Your state was already aligned with what the court just required. You may see some tidying up around the edges, but nothing seismic. If you live in Washington, Oregon, Colorado, Michigan, Pennsylvania, or Florida, you're in the middle ground. Some waiting periods, some training mandates, some local discretionary systems that are now unenforceable on their face, but not the full permit-to-purchase architecture that defined the most restrictive tier. If you live in California, New York, New Jersey, Illinois, Massachusetts, Maryland, Hawaii, Connecticut, Delaware, or Rhode Island, you just watched your state lose 10 or more major gun restrictions in a single morning. California's 10-day wait drops to background check time, which runs anywhere from minutes to a couple of hours. The Firearms Safety Certificate, their version of a permit to purchase, is no longer a legal prerequisite for buying a handgun. The May-issue counties, the ones where sheriffs had been running what amounted to private veto systems over who got to carry, are finished. New York's Concealed Carry Improvement Act training requirements are void. Illinois' FOID card system, the one Maria had to navigate before she could even step into a gun store, struck down. New Jersey's permit to purchase invalidated. Now, here is where I need you to pay close attention, because this is the part that will determine whether this ruling protects you or gets you arrested. The Supreme Court issued this ruling. That ruling is the law. But the systems in these states do not vanish automatically the morning after the decision. Gun stores in California did not wake up on May 8th running under new rules because a dealer printed out the opinion and taped it to his wall. State attorneys general, local law enforcement, county clerks, permitting offices, they operate on their own timelines. Some are moving toward compliance immediately. Others are waiting for guidance from their state governments. Others are being told explicitly by their governors to keep current procedures in place while the state weighs its legal options. This means there is a gap right now, potentially weeks, potentially months, between what the Constitution says you can do and what your local government will actually allow you to do without arresting you. Do not walk into that gap assuming the ruling is a shield you can wave at a police officer. It is not. What it is the strongest foundation that has ever existed for a civil rights lawsuit after the fact. But after the fact means after you've been charged, after you've hired a lawyer, after your life has already been disrupted. Know what your state is doing right now. Know whether your local officials have issued compliance guidance. Act on the right when the system is actually ready to honor it, not the moment you feel like it should be. Subscribe right now because over the next several weeks, I'm going to be tracking exactly which states are complying, which are stalling, and which are crafting workarounds designed to technically satisfy the ruling while functionally maintaining the same barriers. You need to know which category your state falls into before you make any moves. The media coverage of this ruling has been, in a word, disgraceful. Not because it was inaccurate in the narrow factual sense. Most outlets correctly reported the vote count and the basic holding. What they buried, minimized, and in some cases refused to address directly was the significance of the unanimity. I watched every major outlet that covered this story. Most of them mentioned the 9-0 vote in passing, treated it as a footnote, and then spent the bulk of their coverage on gun control advocates expressing concern. Not one of the primetime broadcasts I watched led with the question every serious legal journalist should have been asking. Why did Sotomayor, Kagan, and Jackson sign this? These are not swing votes. These are not justices who occasionally break from their ideological block-on-edge cases. These are 3 justices who built their public legal reputations in part on the position that reasonable gun regulations survive constitutional scrutiny. Sotomayor wrote dissents in Bruin that were scathing. Kagan has been explicit in opinions and in public commentary about her view that courts were overreading the Second Amendment. Jackson came to the court after Bruin and has never once voted to expand gun rights. And then on May 7, 2026, all 3 of them signed an opinion written by John Roberts that establishes strict scrutiny for the Second Amendment and strikes down 5 foundational categories of gun control law. There is only one reason that happens. The restrictions being challenged had become so legally indefensible, so disconnected from any historical tradition, so poorly tailored to any compelling government interest, so impossible to justify even under generous scrutiny, that these 3 justices looked at the record and decided they couldn't write a dissent that held together. That is not a political statement. That is a legal conclusion. And the press, which has been covering gun law through a political lens for so long it has forgotten there's a constitutional one, missed the story entirely. What Roberts wrote is not a narrow holding. The language he chose, the default is liberty, government may not condition the exercise of this right on permission or delay beyond eligibility verification, is language that will be quoted in federal courts for the next 50 years. It is language that places assault weapon bans, magazine capacity limits, age restrictions above 18, and red flag laws without robust due process procedures all squarely in the crosshairs of strict scrutiny challenges that are now substantially more viable than they were on May 6th. The press didn't explain that. They gave you the vote count and the outrage takes. They did not give you the legal architecture that was constructed inside that opinion and what it means for every gun restriction that was not directly struck down today but is now standing on a foundation that just cracked wide open. Here is what comes next. And I want to be very precise about this, because there is a version of this story being told right now that overstates the victory, and a version that understates it, and both of them will lead you wrong. The constitutional question at the center of Henderson is settled. Strict scrutiny applies. The 5 categories are gone. Those facts are not going back. No lower court can relitigate them. No state legislature can pass a law that undoes them. The Supreme Court spoke unanimously, and that is about as settled as American law gets. What is not settled is the second wave. The states that lost the most are not accepting this quietly. California's Attorney General has already announced the state is reviewing its options. New York's legislature was in emergency session within 48 hours of the ruling. Illinois, New Jersey, and Massachusetts are all in the same posture, publicly saying they'll comply while privately drafting replacement systems engineered to recreate the same functional barriers through different legal mechanisms. They will replace permit to purchase with mandatory free training that takes weeks to schedule and is only offered in limited locations. They will replace waiting periods with cooling off language tied to mental health screening processes that conveniently take 7 to 10 days. They will replace may issue with shall issue plus 20 objective requirements, each of which demands documentation, fees, and processing time. They will rebuild the wall with different bricks and dare the courts to knock it down again. And the courts will. Strict scrutiny is not a one-time application. It is a standard that has to be applied to every restriction, including the new ones. Every workaround law these states pass will face immediate litigation from the Second Amendment Foundation, the Firearms Policy Coalition, and a half-dozen other organizations that were ready for this and are already mapping the next rounds of challenges. Those challenges will move through federal district courts, through circuit courts, some of them back to the Supreme Court. That process takes years. During those years, the workaround laws will be in effect in the states that pass them, and people who try to exercise the rights Henderson recognized will sometimes run into the new barriers and have to decide how to respond. Support the litigation organizations? Not because I'm telling you to, but because they are the mechanism by which this ruling actually gets enforced when states decide not to honor it voluntarily. The Supreme Court does not have a compliance department. It does not dispatch federal marshals to make sure Illinois updates its permitting system on schedule. Enforcement happens through lawsuits, and lawsuits cost money. And the states have unlimited legal budgets funded by the taxpayers they're restricting. The gun rights organizations fighting these battles do not. The gap in resources is real, and it matters. There are also restrictions that Henderson did not address, and I want to be clear about what they are. The ruling struck down the 5 categories I described. It did not directly rule on assault weapon bans. It did not directly rule on magazine capacity limits. It did not directly rule on red flag laws. It did not directly rule on age restrictions beyond the federal minimums. What it did was establish the standard those restrictions now have to survive: strict scrutiny. And under strict scrutiny, the prognosis for most of them is not good. But not good under the new standard is not the same as already struck down. Those fights are coming. They are not here yet. The distinction matters. Rights that exist on paper but require a lawsuit to enforce are still rights worth having, but they are not the same as rights your government is prepared to honor when you walk through a door and ask. Know the difference. Insist on the first. Work to close the gap between the two. Because that gap between what a court says you have and what the system is willing to give you without a fight is where people get hurt, where lives get upended, where the abstract language of constitutional law meets the specific reality of a person trying to protect themselves in a neighborhood that the government failed long before it decided to restrict their rights. Maria eventually got her gun. It took longer than it should have. The man she was afraid of had 2 more incidents before she was legally armed. She is fine now. A lot of people in her situation were not. The question this ruling forces, the real one underneath all the legal doctrine and the vote counts and the Attorney General's statements, is how long a society can justify making the most vulnerable people wait for rights the Constitution already gave them. And the answer the Supreme Court just gave 9 voices in complete agreement is that it cannot justify it at all. Whether the people running these states have the honesty to accept that answer is the fight that starts right